Good morning, everyone, and I'd like, first of all, to address you with a very warm welcome to today's webinar. It's once again a pleasure to have the chance to spend these couple of hours together with you this morning. I am trying to show you the services screen of the European IP Helpdesk before we start with our webinar, which introduction to plant varieties today. We have the pleasure to have the chance to carry on our relationship with the Community Plant Variety Office of the European Commission, and today we have two speakers together with us, Ursula Lamberti and Angela Martinez Lopez. Thank you very, very much once again for accepting the invitation and taking the time, very valuable time, to be here with us today. Before, however, I leave the word to our two experts, and before we start with the technical content, as I usually do, I'd like to take from you a couple of minutes in order to introduce you to the tool that we are using today, which is GoToWebinar, and also to the services of the European IP Helpdesk. The tool we are using has set you all on muted. That is not because we don't want you to ask questions. You're actually very welcome to do so. However, if we would all produce background noises, it would be pretty much impossible for our speaker to share some information with us. Therefore, if you'd like to ask questions, you can gladly do that through the question part of your screen, which you can see on the right-hand side in the drop-down screen. I will gather all the questions, and at the end of the webinar, we will go through them and provide you with the best answer, of course, we can. In case some of the questions should remain unanswered, you're very welcome to address them to the helpline of the European IP Helpdesk, which I will introduce later on throughout these slides. Also, you will receive today's presentation in a PDF format, and you will also receive a link that will guide you to the GoToWebinar website of the European IP Helpdesk, where by inserting your name, surname, and email account, you'll have the chance to see the webinar once again, how many times you'd like, at any time you'd like. So now we start with the European IP Helpdesk, first by introducing myself. My name is Michele Dubini, and I will be today your technical assistant. I am myself a lawyer as well, but today I will not provide you any information because there are people much more qualified than me to do that. And I will assist you, however, in case you should have problems with your video or audio, simply write that down in the question part and I will do my best to help you with that. My employer, so to say, is the European IP Helpdesk, which is a service initiative of the European Commission that has the objective of helping mainly EU-funded projects, researchers, or small and medium enterprises across the European Union understanding and using intellectual property and intellectual property rights. The services you can see on the right-hand side of the screen are offered completely free of charge, and the cornerstone of all the services is the website, which is ec.europa.eu/IP-helpdesk. And through the website, you can have access to many different services, which you can see in the slides, in the small clouds on the right-hand side. Starting from trainings, which are in the last 2 years have been mainly online. However, we're trying to bring back the on-site form of training once again, probably in the second half of 2022, very, very possibly at the beginning of 2023. And also publications are available online. You can download them and use them for your own purposes. And also for your day-to-day activities. We have an ambassador scheme, which I will introduce later. And also we have, probably most importantly, a helpline, which will answer to your specific questions within 3 working days and in the most possible understandable way. The helpline is sitting currently in Alicante, and our experts from different nationalities are waiting for you there. They speak many languages. However, we would suggest to ask questions in English if possible, because we're always going to have one expert that's able to speak English and answer to you as quickly as possible. The services I've introduced are valid for European Union countries, so for companies or individual persons or juridical persons within the European Union, or connected Horizon 2020, Horizon Europe countries like the United Kingdoms, like Israel as well, or Norway, or Switzerland, or Turkey as well, other countries that are connected to the research activities and the framework projects of Horizon Europe and Horizon 2020. If you're looking for information regarding intellectual property rights outside the European boundaries, you can check out the China IP SME Helpdesk, India, Southeast Asia, Africa, and Latin America IP SME Helpdesk. They are there to help you exactly with the same topics I described to you for the European Union, but outside the EU. I've talked about the website, trainings, publications. Also, I'd like to mention that audiovisual content is available online. It is available on YouTube, and our speakers are introducing the topics they tackle in their webinars or in their trainings on the YouTube channel, and also short animated videos regarding intellectual property and IPR are available on the YouTube channel. Also, social media are a platform that we very gladly use to communicate with our audience, and Twitter and LinkedIn are there for you if you'd like to discuss with us regarding IP. We're going to come up with the bulletin number 6, and it's going to be in June 2022. This is our latest, but since we're talking about plant varieties and so on, border of the green topics, I left our bulletin Green Deal. Also, I'd like to mention, since we are from very different countries across the European Union, that we have a large network of experts in the intellectual property fields across the European Union. And they might be very near to your premises, and they might really help you with your intellectual property exploitation and activities, because they are both experts in the IP field as well as part of the EEN network. Therefore, they are, for us, a very, very valuable piece of our puzzle, of our services and of our initiative. If some of them is connected today, I'd like to thank them very much for the work they are doing. I also left a couple of links for further learning opportunities that are connected to the EU WIPO, EPO, and WIPO, if you'd like to know more about intellectual property and intellectual property rights. And the other links that you can see instead are hands-on help by also European Commission related initiatives that will assign you experts, in some cases like the Horizon IP Scan or Leadership for SMEs, in order to solve your peculiar problems with IP and IPR. One last information is that this webinar is being recorded. I have to communicate that to you for GDPR purposes, but also we are doing this only to your advantage, because we want to provide you with the presentation after the webinar has taken place. One last reminder, www.ec.europa.eu/IP-helpdesk is our website, also embedded with the other helpdesk website across the world. And also helpline link and training link if you'd like to ask us questions or receive past training links that you can follow and see. Twitter and LinkedIn. And with this, I have come to the end of my introductory presentation. I am going to leave the word to my two colleagues and allow them to share also their file and PowerPoint presentation in order to learn all together regarding plant variety rights and the creation of new plants and their protection in the European Union. Thank you very much, Ursula and Angela, for being here with me. It's a pleasure to have the chance to hear your presentation.
Okay, thank you, Michele. While I try to show the presentation,
I'm seeing that already.
Can you see it? Yeah?
Yes.
Okay, it would be better to start from the beginning. Okay, can you see it correctly?
Yes, we are at the first slide. It's perfect.
Yes, fantastic. Okay, well, Michele, first of all, let me thank you and the help desk for the opportunity today of raising awareness about a topic that we really care about so much, is the protection of new plant varieties in the European Union. Today, I'm with my colleague Angela, and we are both legal advisors at the CPVO. As you can see in the slide, we have some experience in intellectual property law in general, notably trademark law. Angela is also more specialized in European law, and today we will alternate a little bit in the presentation of the basics of our system. So I will start we will start with the first slide, and I'll leave the floor to my colleague. Thank you.
Okay, so welcome to this webinar. Here you can see on the screen the outline. So basically all the elements that we are going to cover. We will start with a necessary introduction to the notion of plant breeding. We will also be presenting the international and European Union policy setting within which we are placed. Then we will present all the basic elements of the community or European Union plant variety rights system. And finally, we will be providing some interesting links and refer to our databases. So without further ado, let's begin with the first topic, which is this necessary background to plant breeding. So in this section, we will be answering the questions, what is plant breeding? How does plant breeding support innovation? And which are the plant breeding techniques or methods that are available? So first of all, you can see on the screen the definition of plant breeding. So plant breeding is the science of recombining, by the physical use of plants, the genetics of existing plant varieties to create a new plant variety. Now, here we can see on screen a very illustrative example of the method called crossing and selection. So basically what happens here is that a breeder selects the best traits and then crosses the plants, and then again it selects and crosses, and after a certain number of generations, this breeder obtains the desired plant variety. So here we can see a breeder that was interested in the larger size of the bell pepper and was also interested in the texture and the spiciness of the jalapeno variety. So basically this breeder cross-fertilized the variety. So basically he took the pollen or the male gametes from the bell pepper and placed them into the stigma or the female organ of this jalapeno. So then he obtained the progeny or the offspring, and then again selected the ones with the best traits, crossed them again, and then after repeating this exercise for, let's say, 4 generations, he finally got to the final result of this jalapeno popper that combines the 2 desired characteristics. Now here on screen we have another example. This is the crisp pink apple variety that you may all very well know and find in our supermarkets daily. So it's actually commercialized under the trademark Pink Lady, so you may actually know it under the trademark name. And here we see that this breeder wanted to combine the properties of the Lady Williams variety, so the storing properties, with the sweetness properties of the Golden Delicious variety. And by this crossing, this breeder, called Mr. John Cripps, he obtained the Cripps Pink variety. Now, plant breeding aims at creating new plant varieties that are affordable and at disposal of consumers. So actually breeders look for specific traits that render varieties valuable in economic and societal terms. Now, what are those traits or characteristics in plant varieties that render them valuable? So here you can see on screen all of the possible traits that are attractive. And before presenting them, it's necessary to introduce you to the notion of biotic and abiotic stress. So basically, abiotic stress refers to those stress conditions for plants of peak or cold warm temperatures, or soil salinity, drought, toxins with chemical fertilizers. So basically, abiotic stress is the type of stress that relates to fluctuations in the environment. Then we have biotic stress. So this stress refers to the stress caused by certain living organisms, such as fungi or virus, bacteria, insects, and so on. And these biotic stress agents can cause several types of damage, diseases, and they ultimately affect crop productivity. So against this background, breeders want to develop stress-tolerant varieties. And here we can see on screen the pest resistance, for instance. So this is about creating new, stronger, resilient varieties that do not need the application of chemicals, pesticides, and so on. Then we can see reference made to adaptability to climatic conditions. So basically, this can refer to the notion of varieties that require less water input or that are drought tolerant, as I was mentioning. Then we see on screen crop yield. So crop yield is a standard measurement of the amount of agricultural production harvested per unit of land area. So for instance, seed ratio is a way to calculate yields. So how many kilos of tomatoes can we get from 1 kilo seeds, right, for instance? And this refers to the notion of a limited productivity of agriculture and land, because now there is a migration trend of population from the countryside to the big urban conglomerates. So it is necessary nowadays to grow more varieties in a smaller place, so to produce more with less. This is the idea behind. Then we see on screen also early maturity, because indeed nowadays we want to have a global supply of a wide array of varieties all year long. So for this reason, this can be an interesting trait. Then we see the example, we also see varieties that are more nutritious. So this is also related to the health, to human health. And then we also see the commercial value. So for instance, a better aspect. So the commercial value refers to the evolving taste preference of consumers. So in a way, consumers also influence breeding innovation. An example of commercial value would be, for instance, an apple, which is characterized by a hard, crunchy fruit, or by a green, shiny, attractive skin, or by a juicy flesh. And well, the presence of a specific trait in a plant can be the result of genetic modification or mutations that can be induced or naturally occurring, or then a trait can also be found just in the environment. So this is what we call a native trait. And traits are a very important component of innovation. Much investment is being made in trait research, once a trait is found in a plant and is made available on the market, then it is relatively easy to transfer this interesting trait to other varieties, even to varieties of different species. Now, let's have a look to the evolution of plant breeding techniques, because actually the origins of plant breeding can be traced back to almost 10,000 years ago, when the first farmers selected the plants with the best characteristics of the year's crops and to provide the better seeds for the next season. So for many years, this was considered a period of intuitive breeding. There was a whole process of domestication, so to say, and then by the end of the 19th century, we arrived to what we call scientific breeding. So first of all, there was Gregor Mendel that discovered the laws of genetic inheritance in plants, and this was like the cornerstone for further scientific research. And in the intentional crossing and selection method, as I already explained, emerged. And then by the 1970s, with the advent of recombinant DNA technology, this was a revolution for plant breeding because this allowed for the direct manipulation of virtually any gene in a living organism, and this could be done in a faster ways and easier ways. And nowadays there is a coexistence between in the methods of creation of new plants. We can categorize them broadly because it's of course much more complex than this, but we can categorize them into conventional breeding techniques and gene editing breeding techniques. So in very simple words, conventional breeding relies on processes that occur in nature. So for instance, the classical method is crossing and selection, as we have already seen. And then the gene editing breeding, it relies on biotechnology to modify genetic material, and like this to control the expression of genes in a more precise manner. So nowadays, of course, we know this CRISPR-Cas, which has the revolutionary attribute in its accuracy in enabling site-specific mutations in the genome. And it actually serves to accelerate the breeding process. Now, what is the role of intellectual property rights in this scenario? So here we need to mention the theory of social contract applicable to all intellectual property rights systems. And the plant variety rights system is no stranger to this theory. So basically this theory consists in that with intellectual property rights, we are rewarding innovators with an exclusive monopoly so that they can enjoy the benefits of the invention, and they are incentivized as well to keep on innovating. But this monopoly is not unlimited. It is actually limited in time, and after a given period, the invention falls into the public domain so that society can take advantage to the fullest of this invention. Now, plant breeding innovation is a profitable industry of tremendous importance in economic and societal terms, and it creates employment, growth, business opportunities. Plant varieties as product of plant breeding are of a high value. Developing new plant varieties is a time-consuming and costly endeavor, and breeding companies invest in research and development around 15% of their annual turnover. So in quantitative terms, this is quite important. And finally, plant variety rights protection represents a compromise to balance the interests of the breeders with the interests of consumers and farmers. And in the end, the final goal is the public interest and the benefit for society. And now I give the floor back to my colleague Ursula.
Thank you. I'll get the keyboard, just a second. So we just saw what is essentially the subject matter of community plant variety rights, what breeding can do, and all the potentials of this traditional but also very modern technology. We also saw how we intend to protect innovators, but why are they important on the international and European Union geopolitical scene? I will start from the so-called SDG, the United Nations Sustainable Development Goals. This is a series of objectives that were established in the 2030 Agenda. The 2030 Agenda is a sort of agreement among the heads of the member states of the United Nations that realize that we need to do better in our society, in the use that we make of resources, in how we respect, in general, human rights. And the outcome of this agenda is basically these 17 objectives that you can see in the slides, and they encompasses a lot of aspects of our society. There is also points about gender equality, a more fair society in general. But what's interesting and for us today is how plant breeding and innovation, the protection of innovation of plant breeding can contribute to some, at least some of these objectives. I will start from the objective number 2, and I will mention essentially the goal number 2 and 15. Why? Because plant breeding, thanks to this potentiality, and we saw the desirable traits that we can introduce in plants, as the possibility to stop hunger, to feed an increasing population to allow consumers to have access to affordable and nutritious food, while also ensuring a sustainable growth and a use of the land. This is why I was referring to goal number 15. So as you can see, a plant breeding, it is part of intellectual property, which is it's a concept that is sometimes frowned upon. However, it has the potentialities to contribute to these very important geopolitical and international goals. Michele was mentioning before the center of the newsletter of the help desk, and he mentioned the European Union Green Deal. What is this document? This is basically a promise that the Commission of the European Union Commission made as a sort of a political program. This political program has one essential objective, which is making the EU the first climate neutral nation by 2050. You can see that it's a very extremely ambitious objective, and this document also entails a series of actions. How do we get to this final objective? It's somehow similar to the SDG, so it's a program, is an aim, is an ambition that we have as a community in general, and it does have some points that we have to follow. First of all, the essence of this European Green Deal is to ensure a sustainable and inclusive growth. And of course, innovation in plant variety rights, innovation in plant breeding in general, can help in reaching that objective. Staying on the European Union front, we should also mention the biodiversity strategy. It's another programmatic document that includes goals for 2030. And what's interesting, what I feel is interesting in this document is the fact that we do have some numbers. We have very precise objectives, so they're less, let's say, general, and they're more concrete. And of course, plant breeding cannot provide a direct impact on all of these objectives. However, I can see some of them that can be reached thanks to the support to this kind of innovation. And one of these is, for instance, a better management of agricultural land. We saw that also in goal number 15 of the SDG. This is essential in the face of climate change. We need to have more resilient crops on one side. We mentioned drought resistance before, but on the other side, we also have to make a more responsible use of the land that we're given. And some of these crops, enhanced crops, for instance, ensuring a better yield, also ensure the reduced use of the land. So the biodiversity strategy in general lies on the assumption that the more biodiversity we have, the more resilient is our system. And it also, as you saw before, links the objective of a more responsible use of the land. And then we have the farm to fork strategy, also of the European Union, and it has a very specific focus. The farm to fork strategy stays in the framework of the European Green Deal, but focuses on the food chain. The strategy basically identifies some stakeholders that we have to protect, that we have to support. First of all, consumers. Consumers that, thanks to plant breeding, can have access to more nutritious and more affordable crops. On the other side, we should also support farmers and producers in general, who should have a better return on their investment, on their activity. This can also be reached thanks to a wise use of plant breeding. The farm to fork strategy also includes some, let's say, very precise objectives. You can see them here on the screen, and we see again, except for regardless of food waste, which is in general more about our lifestyle in general, but we can see again a better use of the land, and what's interesting, reduced use of pesticides. Angela mentioned before what we can do with plant breeding, and among the potentialities of this technology, there is also the possibility to actually develop varieties that are naturally resistant to pests. This means that we need less chemicals in our agricultural production, and we're less reliant on other countries that produce these substances. Okay, so I also have the honor to present the next section, which is about well, let's say the international and European Union background, legal background that is the basis of the community plant variety rights system. Angela will explain you the basics of the system and how it works in Europe, but we're still lawyers, so we would like to make reference at least to the legal basis. Well, the first essential legal basis is Article 27 of the TRIPS agreement, which only said that European Union and all the members of the WTO, of course, had to create a system to protect new plant varieties. So it was very general, but we knew that that was an objective. How did we do that in Europe? Well, we subscribed, let's say, we were members of the so-called UPOV Convention. The UPOV Convention, like the Madrid system, the Hague system, and is an international convention that establishes the basics of plant variety rights system around the world. The European Union became a member of the UPOV Convention in 2005. The convention has 78 member states, and actually 23 of the 27 member states of the European Union are part of that. What it's interesting to know is that this convention has several acts, several versions, and we are part of the latest one, the 1991 one. This is not the case for all the countries, but this is a completely other story. Very interesting though. So what does the UPOV Convention says, and how did we implement it in the European Union? Well, as every convention, the UPOV Convention has provides some options. So what did we go for in the European Union? Well, first of all, we created, on the suggestion of Article 27 of the TRIPS agreement, a sui generis system. What does it mean? It means that it's not a patent on plants, it's not a trademark, it's not a design, it's a completely different intellectual property right. We saw before that it does, of course, like other IP rights, follow the social contract theory, so the incentive to innovators, and it tries to give an award to innovators, but it does have some peculiarities that are necessary, since the subject matter is something that is alive, is a living organism, is the plant. So the way that we implemented the UPOV Convention and on the basis of the TRIPS agreement is the so-called basic regulation. It's the Bible of community plant variety right in the European Union, and it's Regulation 2100 from 1994. I should specify in this case that we call it community plant variety right, but when we say community, we do mean European Union. You have to consider that this regulation was drafted when we were still in the European community, so it's a little bit vintage wording. This is not our only piece of legislation. I will not go into details, but the practical aspects of community plant variety protection in the European Union are also regulated by other pieces of legislation, and I leave them on the screen, but you can find them on our website in the section Legislation in Force. According to the basic regulation, the Community Plant Variety Office is established as a European Union decentralized agency. What does it mean? It means that in principle, the function of implementing a system for protection in the European Union is of the Commission. The Commission gives this competence to an agency, and this is the office that we work for, is the Community Plant Variety Office with base in Angers, in France, in case you didn't know. It is responsible indeed through its administrative council for running the system of protection. I'm leaving here the organigram because it's very important that we consider on one side that the Community Plant Variety Office is self-financed, is financed on the basis of the fee. the fees, and we will see about the fees later. And on the other side is managed not by its president or vice president, but by the administrative council, which is an organ that not only has budgetary competencies, but is composed of the member states of the European Union. So this is very important because it means that the member states of the European Union give this competence and then monitor how the Community Plan Variety Office carries out its mission, which is in this slide. What is our mission? Is to deliver and promote the system of protection that as it was established in the UPOV Convention. We have to run it, we have to raise awareness like we're doing today, and we do this for the benefit of society, the benefit of society that you saw as the outcome of the social contract theory before. And now I can leave the floor to Angela, who will explain you how the process of application for a right works. Thank you.
Yes, so indeed, thank you. In this section, we will learn what is the subject matter of protection under a European Union plant variety right. We will also learn what are the requirements that a variety must meet in order to be eligible for protection. And then we will walk together through the different stages in the examination process of a variety. So first of all, we need to know what is the object of protection. So what is the subject matter of a European Union plant variety right? So that is the plant variety. And to understand what a plant variety is, we need to understand a bit about the taxonomy discipline here. So basically, taxonomy is the discipline of classifying organisms into taxa or categories. And all living organisms are grouped in 6 kingdoms. So here we are concerned with the plant kingdom. And a plant variety is the most specific description of organisms in this plant kingdom. Now, more specifically, we have a legal definition, which is in Article 5 of our basic regulation. And here, a plant variety is defined as a plant grouping within a single botanical taxon of the lowest known rank, which can then be defined by the expression of the characteristics resulting from the genotype. So this means defined by the phenotype, so what you see. Then this plant grouping must be distinguishable from others by the expression of at least one characteristic. So again, this means that the variety must be clearly distinct in at least one characteristic from other varieties. And then there is the requirement that the plant grouping is considered as a unit suitable for unchanged propagation. So in essence, a variety is the most tangible, let's say, classification in the overall taxonomy of plants. Here we have a visual example of the taxonomy of apple varieties. So we see on top the kingdom, which is the plant kingdom. Then if we go down, we have the clade angiosperms. And here, basically, this is all flowering plants. It covers the most diverse clade of the kingdom. Then we go one step down, we have the order, which is Rosales. And this encompasses flowering plants of 7,700 species. So here we have roses, strawberries, blackberries, cannabis, and so on. Then we go down to the family, which is Rosaceae. So it's the rose family. We go one step down and we have the genus, which is Malus. And this comprises about 50 species, so domestic and wild apples. Then again, we go to the one step down to the species. Here we have the Malus domestica, so domestic apples. And finally, we get to the tangible unit, which is the variety. And we're going to see now some examples of popular apple varieties. So you can see on screen, for instance, Braeburn, Crips Pink, Gala. And these varieties, many of these are very successful, and then the breeders actually create mutants from these varieties. Now, what plant varieties can be protected? Well, the answer is easy. All botanical genera can be protected. Any genera, any species, any plant variety belonging to any genera or species, in essence. And so far, the CPVO has received applications for over 2,300 plant species. So let's get a bit into let's delve into the process of an application for a European Union plant variety right. So let's explore the benefits of this system. So the first important element is that any physical or legal person can apply for a European Union plant variety right before the CPVO and in any official language of the European Union. And then it's an advantage that with one single application and with one procedure, including one technical examination, the CPVO reaches one decision, whether to reject the application or whether to grant this plant variety right. And if this plant variety right title is granted, then it is valid and enforceable in the totality of the territory of the European Union, so in the 27 member states of the EU. And who are the breeders to which we are referring during this time? So the breeder is the person who bred or discovered and developed a variety. So it's important to focus here on the word "and", because this serves to emphasize that a mere discovery where no human action has been undertaken cannot be protected under a plant variety right. This is consistent with the theory of social contract that we have already presented, because in essence, we want to reward with an intellectual property right those inventors that have made an effort to create something new. That's why we don't reward a mere somebody for a mere discovery in nature. Now, a different question is who is entitled to a European Union plant variety right? So again, it can be the breeder, but it can also be the employer of the breeder. This really depends on the national law applicable to the employment contract at hand. So sometimes it's the employer, sometimes it's the breeder, and it depends, as I say. And then another person entitled to the plant variety right can be the successor in title of either the breeder or the employer, as we have seen here. Now, this slide here, you can visualize like all the process of application for a plant variety right, how the examination goes. So as a first step, you see here the registration of the application. So first of all, the office grants a date of application, and then the examination proceeds. This examination is a triple-fold. So basically there is a formal examination, a substantive examination, and a technical examination. So the formal examination is concerned, as its name indicates, with the formal aspects of the application. So for instance, the application must contain given a number of elements. So for instance, the identification of the botanical taxon of the variety or the name of the breeder and so on. And in the formal examination, the office also checks that the application fee has been paid. Then we have the substantive examination, which is aimed at verifying that the application concerns a variety as subject matter, that the variety complies with the requirement of novelty, and then whether the applicant is entitled to the application. And also this examination covers the examination of the suitability of the denomination or the name of the variety, as we will see just in a moment. Then we have the technical examination, which is the testing that is aimed at verifying that the variety at stake complies with the technical requirements. And we will also check that in a moment. So finally, after this examination is complete, the office reaches a final decision, which, as I say, can be to grant the plant variety right, or if some elements are not complied with, then the office proceeds to refuse the application. Here on screen, you see the requirements for the grant of a plant variety right. So on top, you see the technical requirements. These are the distinctness, uniformity, and stability requirements. And then you see the novelty requirement and the requirement to designate the variety by a denomination. We are going to explore these requirements in more detail. So here you see the technical requirements that are commonly referred in expert cycles as DOS requirements, because the D stands for distinctness, the U for uniformity, and the S for stability. Now let's focus in more detail in these requirements. So here we have the D, the distinctness, and a variety is deemed distinct if it is clearly distinguishable in the phenotype from other varieties of common knowledge on the date of application. So what are these elements in the definition? Well, first of all, the characteristics must be distinguished that distinguish a variety are those observable at phenotypic level. And then, well, the requirement of distinctness lies at the very heart of the rationale of the industrial property protection for plant varieties, because in essence, it means that a breeder has been able to provide a new variety to the state of art. And then here, the distinctness of a variety is assessed in relation to the varieties of common knowledge. So here, the most similar varieties in the common knowledge are selected. These are the reference variety, and then this candidate variety will be compared with these reference varieties in a direct growing trial. Now, the U in the DOS, this is the uniformity. So a variety is deemed uniform if it is sufficiently uniform in the phenotype, in essence. So this means, for instance, that if you see all the plants, you focus, for instance, of the leaves, so all must have the same shape, or the flowers must be of the same color. There must be a homogeneity, let's say. And then, of course, a certain degree of variation can nevertheless be tolerated, because the variability of a variety depends particularly on its propagation process. So the level of uniformity, or the threshold of uniformity expected in one variety, may differ from another, depending on the concerned species. And then we arrive to the S in the OS, which is the stability. So a variety is deemed stable if the phenotype remains unchanged after successive propagations or multiplications. So this means that after a few generations, the variety should still keep its characteristics. So for instance, you can think of a pink rose. This pink rose should be still pink after repeated propagation. It should not start becoming a little bit whitish, or no, the color needs to be stable. So actually, the stability feature of a variety is linked to the feature of uniformity, and normally if a candidate variety is deemed is uniform, it is also deemed to be stable. Here we arrive to the novelty requirement. So a variety is deemed new if at the date of application, material of this variety has not been sold for commercial exploitation by the breeder earlier than 1 year before the application date within the European Union, or earlier than 4 years before the application date outside the European Union. And in the case of trees or wines, that is 6 years. So what does this actually mean? So this means that plant breeders are afforded of a period of grace during which a variety can be marketed before the date of application of the European Union plant variety right. But then if the variety is established to have been marketed outside this relevant period of grace, then it can no longer enjoy protection under a plant variety right. And well, very important, the notion of novelty here, as you can see, is understood as a commercial novelty. So there needs to be an exploitation for profit and an evident desire to make sales. Then we have here the requirement of the variety denomination. So a denomination is the generic designation of a plant variety. So it's a requirement for the grant of the plant variety right, but it's actually not part of the intellectual property rights. It is merely a regulatory element, and it is for the applicant of the plant the applicant for the right to propose the denomination, and then the CPVO assesses whether it is suitable or not. So there is an examination, and actually the CPVO has some very detailed rules that can be found in the CPVO guidelines with explanatory notes on denominations on a website in case you're curious and want to check them. And well, once a denomination is registered with the CPVR, there is an obligation to use this variety denomination when marketing, propagating material of the variety. And this applies not only to the holder of the right, but also to any third party commercializing the variety. And this requirement persists even after the expiration of the community plan variety right. Now, the technical examination, let's have a quick look because it's a core part of the examination process. So the technical examination examines, as I said, the compliance with the DOS requirements that we have seen. The CPVO has no technical infrastructure to do this. Actually, the examinations are decentralized in one of the examination offices on which the CPVO relies. These examination offices are in charge of conducting a growing trial where they compare side by side the concerned varieties, and then this examination concludes with a technical report that can be positive or negative depending on whether the technical requirements have been complied with or not. And if the final report is positive, a variety description is issued. And then also important to mention that for this technical examination, the examination offices rely on the so-called CPVO technical protocols, which define the conditions under which the technical examination must be carried out. Here on screen, you can see all of the examination offices that have been entrusted on behalf of the CPVO. So as you can see, distributed throughout the whole territory of the European Union. And well, finally, if all the requirements of all these threefold examinations have been complied with and no impediments have been identified, then the CPVO proceeds to grant the European Union plant variety right, along with an official description of the variety, which is, so to say, the identity card of this variety describing how it is. And then also to mention what are the fees here. So there is an application fee of 450 euros for online applications. It's almost the double if the applications are made on paper, although nowadays we almost have no paper application. And then for the technical examination, then there is a fee ranging from 1,900 euro to almost 4,000 per growing cycle, and this depends on the species. And then also important to mention, if a holder wants to maintain the right in the register, then this breeder needs to pay an annual fee, which is of 130 euro. Now here on screen, you see some CPVO statistics dating from the period that goes from 1995, from the inception of the system, until nowadays, 2022. So you can see that 77,000 applications have been filed. So approximately we have now about 3,500 per year. And then from these applications, 61,000 community plant variety rights have been granted. So that is like 80% of the total number of applications. And then nowadays we have more than 30,000 community plant variety rights still in force. So that is like half of all the CPVRs that have been granted in all of this period. And now I give the floor back to my colleague Ursula.
Thank you. Okay, so we saw a very complex application procedure for obtaining a community plant variety right in the European Union. Why is it so complex? On one side, you have to consider, as we mentioned before, that we are dealing with a live matter, so we have to observe the plants in the growing trial, and this is because this is the reason why not having an infrastructure, we need examination offices. On the other side, we have to consider that we are granting a monopoly, so an exclusive right. This is a big deal. It's a right of property, and as all right of property, this can be a contentious matter. Contentious matter means that people may have disagreements about the grant of a community plant variety right, and they have, of course, many tools to address their doubts, their arguments, their claims. Here I will explain you very briefly what you can do before the CPVO when it comes to legal proceedings. First of all, I will start from objections. Objections are filed before the grant of the CPVR. You have to consider that after the application, there is a publication on our Gazette of the facts that we receive this application for protection, right? From that moment on, and before the grant of protection, that may take a few months, few years, any interested person can raise an objection to that grant. On what basis? We went so much in depth in the requirements because you have to consider that an objection can be based on those requirements. So there is basically someone who's saying to the CPVO, you should not grant the right because this variety, this candidate variety, does not satisfy the US requirement, is not novel, the entitlement is not right. Typically, they say it's mine, it's not of the applicant. The other proceedings that we see are the cancellation and nullity proceedings. I'm not quoting the basic regulation. I invite you to read Article 20 and 21 for an official definition of these proceedings, but basically the objective of these petitions is to delete a CPVR that is already granted from the register. The difference between nullity and cancellation is the effect that has the decision, the final decision taken during the proceedings, and the rationale behind it. When it comes to nullity, the nullity petitioner is telling to the office that the right, the CPVR, should have never been granted. On the basis of what ground? That the variety was never distinct, was not new, if we can use a patent wording. It was not different from the common knowledge at the time of the application. So we got it wrong. We didn't have enough information, or it was not uniform. It was not stable at the time of application, or the entitlement was never right. And this is why when a nullity petition is successful, the decision on the annulment or the declaration of the right null and void has an effect as of the outset, so as the right was never granted. The situation is different for cancellation. Cancellation is typically invoked by a party or ex officio by the office when the right does not deserve protection anymore as of a certain point in time. Typically, the most common ground for a cancellation is the non-payment of the annual fee. Every year, in order to keep the right alive, let's say, it is necessary to pay an annual fee. If this fee is not paid, then the right is cancelled, not from the date of application, but from the date of the decision. All these proceedings together, all these proceedings end with a decision. Also, the grant is a decision, a refusal of protection is a decision. All these decisions can be appealed before the Board of Appeal. The Board of Appeal is an independent body. We saw that very quickly in the organigram. It's separated from the rest of the organization of the CPVO. And it has the function of assessing the legality of the decision that we take. It gives a second set of eyes on what we are deciding, what we're doing, and our practice. This is quite common also for other European Union agencies, including the Trademark Office, for instance, and the Chemical Agency. It is composed of one permanent chairman who decides on a case-by-case basis who are the other members from a list. They are legally and technically qualified, who should assess whether we took the right decision. If you're not happy with the decision of the Board of Appeal, there's always the possibility to appeal before the General Court and the Court of Justice that is placed in Luxembourg. And this ends our section on the legal proceedings before the CPVO. We said before, the European Union plant variety right is an exclusive right. It's a very big deal. We're giving the monopoly to the breeder. We want to reward him for the big efforts that he did, maybe 10, 15 years of research, and it is a right of property. We say that it has a uniform protection. It's very similar to community design and European Union trademark, and unlike European patent, for instance. instance. What does it mean, uniform protection? It means that there is the possibility for the breeder, by filing an application in front of the CPVO, to have protection in all the 27 member states of the European Union. A uniform protection also means that the transfer of the right is transferred in the 27 member states. The termination or the nullity and cancellation, etc., also is valid in the 27 member states. This does not mean that the breeder cannot seek the national route, so national protection. We saw before that 23 of the 27 member states of the European Union are part of the UPOV Convention, so they do provide the possibility of protecting plant variety rights on their territory. However, we have Article 92 of the Basic Regulation that reminds us that there is a prohibition of cumulative protection. What does it happen? That regardless of whether the national right was applied for before or after the community plant variety right, the community plant variety right always prevails. We say sometimes that the national right stays dormant, cannot be invoked. The period of protection. According to Article 19 of the Basic Regulation, the duration of protection of a community plant variety right is either 25 or 30 years. We mentioned again the theory of social contract. We do want to grant a monopoly to the breeder. We do want to award his efforts and the innovation that he provided, but then this innovation has to be given back to society after a certain amount of time. So after 30 years that he got royalties, we see how, on the basis of which legal basis he needs to give back this innovation to society, and anyone must have the possibility to use it. So the extent of duration depends on the species, and we see that for all species is 25, and for this species that you see on the screen is 30 years. The scope of protection is established by Article 13 of the Basic Regulation, and here we have a list of acts where the authorization of the breeder is requested. In other terms, when you want to carry out reproduction of the protected variety, you want to offer it for sale, but also you want to carry out ancillary activities like the stocking and just putting it in storage, you need the authorization of the breeder. The breeder has also, of course, the possibility to condition his agreement to a payback. This payback are the royalties. So in this case, for carrying out all these acts, we need to pay royalties to the breeders, unless the breeder doesn't care about that, and then that can be done for free. On which material? The material scope of CPVR is also very interesting, is very special. It is different from what we see in patents and trademarks, and it is essentially on the variety constituents. Variety constituents are any part of the plant from which it is possible to reproduce a new individual. I cannot tell you that it's the stem, the flower, the leaves, because this really depends on the species. Once again, we're talking about living organism, every single one of them with different characteristics and ways to reproduce itself. So usually the material scope is on that. On the second instance, it can be on the harvested material, so typically on the fruit and flowers of the species. Here we have a very nice example with grape. And finally, we have to consider that the protection does not extend to product obtained directly from the material. So the wine, in this case, or a strawberry jam, or any other derived product. Limitation. If you're familiar with other IP rights, you may know that the monopoly is never absolute. There are always some exceptions and limitations. Why is that? Because we still want to protect innovation. We still want to protect the technological progress. And this is why, for instance, we allow the use of a protected variety for experimental purposes. Limitation means very simply that we do not have to request an authorization to the breeder, as we saw in Article 13 of the Basic Regulation before. If we do not have to request an authorization, it means that the breeder cannot ask for royalties. One of the two most important limitations that are very peculiar of the plant variety system, because the others, you may have seen them in patents, no? Like the private use, but these two are really, really peculiar. First of all, farm safety. You have to consider that farmers, since the dawn of time probably, have been reusing the seed that they have been cultivating in their fields. What they do is that they grow a certain crop in one cycle, and then they put aside a quantity of seeds for the next sowing season. This is a practice that we do not want to avoid in the European Union, but on the other side, we still have to protect the interests of the breeder. So what do? We apply Article 14 of the Basic Regulation, which says that for 21 crops, so a limited number of crops that are very important for our agriculture, this is potatoes and fodder, there is the possibility, when acquiring legally a protected variety, to reuse this in the farm, in the hold of the farmer. Of course, there should be still an equitable remuneration, so a little bit of return for the breeder who put a lot of effort, but this remuneration is clearly lower than any royalty. And as you see on the slide, small farmers should not pay this equitable remuneration because they have a very small farm. They use it only, not for non-commercial purposes, only in their hold. And the second limitation that I think is very peculiar and very special of the community plant variety system is the breeder's exemption. You know very well that in patents, there is the possibility to build upon an invention that is already protected. However, this possibility comes with strings attached. In the case of the breeder's exemption, there is the possibility for any breeder to use a protected variety for breeding a new one, a new improvement, without asking any authorization, without paying any royalty. Why is that? Because unlike inventions or mechanical inventions that can be created from nothing, plants cannot be created from nothing. We always need material to start from. And the breeder's exemption allows and the new breeders, the future innovators, to have the access to the best material and genetic diversity. Enforcement of CPVR. You may know that once an intellectual property right is granted, there is the possibility of infringement. When we have a very successful variety, everyone wants to jump on it and piggyback on the innovators and the market share that it gets. At the CPVO, this is very important. Our mission is, you will remember, is to run and promote a system for protection. However, there is not EU-wide enforcement system. So the enforcement in case of infringement, when someone is copying your plant variety, has to be done in front of the national courts. There is a division, and this is contained also in the basic regulation. On one side, the national judges have exclusive competence to assess the infringement because they are closer to the infringement. They know what's happening and they have access to the police and to investigation tools. On the other side, the Community Plant Variety Office has the exclusive jurisdiction in establishing whether the right is valid or not, nullity, cancellation, entitlement, etc. And finally, since infringement is assessed by a national judge, of course, the either to be followed depends on the national procedural law. And this can be criminal or civil law. It really depends on the national legislation because sometimes the infringement of intellectual property rights in some nations, in some member states of the European Union is a criminal offense, and this is not the case for all of them. I will end this with Article 101. You may ask, where do I go to litigate you just told me that the community plant variety right covers the 27 member states. How can I choose what is the national judge in charge of assessing my infringement case? Well, Article 101 gives us some criteria that can be followed and in order to decide which is the judge that can help me. And we go to the last section.
So in this section, we will be having a look at what are the CPVO databases, and I will also introduce to you some interesting links in case you want to learn some more. So first of all, it's necessary to mention the CPVO register. So here you can find the applications for plant variety rights that have been published. And then you can also find all the European Union plant variety rights in force, and it's a public register. Then there is also the variety finder, where you can search for a given variety by entering its denomination. It's a quite encompassing database because there are also other registers. As you can see, we have 174 registers from 70 countries. So our data is being fed by other states or organizations. And we have, for instance, data on trademarks for registered for plants. And we also have, as I say, national registers, commercial registers, and so on. Then we also have a database with plant variety rights related case law. So here you find all decisions of the Board of Appeal of the CPVO, also the judgments of the Court of Justice, and you also have a national case law. You also have the relevant decisions of the EUIPO Boards of Appeal on trademarks for plants. And you may also want to check the case law booklets that are available on our website, and you can download the booklet, and then you can see some summaries of all the decisions of the Board of Appeal of the CPVO and the judgments of the General Court and of the Court of Justice of the European Union. Then I invite you also, of course, to subscribe to our CPVO newsletter, where you can hear more about our regular activities in more detail. And then there is also a section with all the CPVO, with the history of the CPVO webinars that we have already provided. And also every year we publish an annual report where you can learn more about the, again, about the activities of the CPVO, what has happened throughout the year for us, and also you can see some statistics. Now, I want to emphasize that now we recently work together with the EUIPO in a very important joint study on the impact of the community plant variety rights system on the European Union economy and the environment. So you can find it on our website and also on the EUIPO's website. And actually, my colleague Ursula will be providing in December a webinar where she will be giving more details about this study. And well, by way of conclusion, we have arrived to the end of this presentation. I want to emphasize in the multifaceted nature of plant variety rights, because this is something that is very fascinating and particular in our field. So this basically means that plant variety rights can impact many areas in very different ways. So for instance, we can think of the area of biodiversity or the food supply, the agri-food supply chain, the environment, and so on. So plant variety rights have a very important role in our society, in our economies in the European Union and beyond. And it's important to emphasize that the plant variety rights system does not exist in a vacuum. So basically it is placed rather in a multifactorial context. So this means that the breeders must always consider a complex conglomerate of varieties, variables. And this is why our plant variety rights system needs to be considered in a holistic context, bearing in mind all the relevant interrelations with other disciplines. And to conclude, so after China, our community plant variety rights system is the largest plant variety rights system in the world in terms of applications. Then the community plant variety rights system continues to attract breeders. So for now, we have reached the milestone of 30,000 community plant variety rights enforced. And we take it as an indicator that we are doing something well, because breeders keep trusting us and relying on our services. And finally, I also wanted to share that the CPVO has a strong network of cooperation. which includes national plant variety right authorities and examination offices, breeder associations, international organizations, European Union institutions, and finally, another remark that I want to share is that, as my colleague Ursula was saying, there is now a momentum for plant variety innovation because plant variety rights have now been brought into the spotlight in the context of the United Nations Sustainable Development Goals, also in the context of the European Union Green Deal. So this really represents an extraordinary opportunity for breeders of all types, so be it multinationals or be it SMEs. This represents a turning point. So finally, we hope that you have enjoyed this presentation. We thank you very much for your attention, and we are available now for any question that you may have. Thank you.
Thank you.
Thank you very much to you both. It was a very interesting presentation. And there is already one question by one of the members of the audience. While I share my screen, I would also like to mention that the slides and recording are going to be sent to you at the latest tomorrow morning. That is statistically the most frequently asked question, I would say. Let me see if you can see the screen. Yes. Okay. The second question that we have is from, it's, did you not mention to take over of the TUS? No, maybe, I don't know if you understand it correctly, perhaps it should be a little contextualized, but if you already have contextualized in your head, you can answer the question, otherwise I can ask for a precision.
Okay, so indeed there is a limited time here, so we really need to go through the very basic elements of our system. But indeed there is the possibility, as this person remarks, to take over of DOS reports or the final report of technical examination of that examination offices carry out at national level. So in these cases, the CPVO can rely on the basis of this final report. So this is for the reasons of efficiency, we take over the report, and then we, as I say, we deem it as valid in order to decide whether to grant or not the community plant variety right. So indeed, this is a possibility.
Thank you. While we wait for potential next upcoming questions, I'd like to remind that in case you should not ask for questions throughout the webinar, but maybe you should have questions later on, you're actually very welcome to write the question to the European IP Helpdesk helpline, and we're going to be very happy to answer to your questions as soon as possible. While we wait for further question, actually one has arrived by Rosaline, and it's about costs. So I'm going to show it to you. Thanking you very much for the explanation. How much does it cost? I think the registration fees and so on.
Well, as Angela was explaining before, the application fee is either 450 euros for online applications and 800 for paper applications. Then you have to consider that there is an examination fee. You saw a range in our slides, and this depends on the species. Please consider that assessing and examining one species or the other is not always the same, does not entail the very same cost, and consider also that the examination offices are placed in different parts of the European Union or outside of the European Union, actually, in some cases. So the examination fee can go from 1,500 euros to almost 3,000, and that has to be paid for every year of examination. Some species require just 1 year of observation, and some others may require more years. This is also explained in the technical protocol. That was also mentioned by Angela before. The protocol is the manual that tells to the examiner how to observe that particular species. And finally, there is the annual fee. This is 330 euros to be paid every single year to keep, as we said before, the CPVR alive. I hope this replies to your question.
Thank you. And question number 4, can a plant variety be granted just based on molecular markers as distinctive features?
Well, basically, our European Union plant variety rights system, or actually the plant variety rights system as conceived at UPOV level, is based on the phenotypical analysis. So we observe what makes distinct a variety in terms of the observable characteristics, the phenotype. So, of course, we know that there is much research nowadays in innovation in molecular markets and so on, and the role of how they can assist innovating plant varieties is it's coming to the forefront nowadays. But for now, our system is designed and conceived in, as I say, in this way of really assessing the varieties at phenotypical level.
Maybe we can add something about that. That it is true that in the observation, we are not able to base, as Angela was saying, our decision on the results of molecular markers examination, however, test. However, these are a very important tool for us, and the CPVO consider them to be used in supporting activities. For instance, we are financing some projects that imply the use of markers in the selection of reference collections for some species, and this project that is still ongoing is already showing very interesting results, and they can be used, for instance, to have a smaller reference collection to compare the candidate variety with only the right common knowledge instead of many individuals. So this is also an issue of sound administration and a quicker treatment of the file, let's say. Thanks.
Thank you very much. While we wait for further questions to come up, I wanted also to remind to all the audience that the cooperation with this video does not end today and actually has not started today. We have already carried out a couple of webinars this year, and we will be even more active in the second part of the year. So once you see in blue here are the webinars that are going to come up in the second part of 2022. If you'd like, you're very welcome to register and take part in them. You can have access to this page by the European IP Helpdesk website. And instead, if you missed one of the previous webinars on the 17th of February and the 12th of April, you can actually simply write us and request to have access to the recording and the PDF slides, and we're going to send them to you right away. There's another question, which is from Nada, who's asking, is there a link between PVP and trademarks and patents, or other IP rights in practice? So I think the webinar that we're going to have on the 8th of September is going to answer to this question, and that's also the reason why I showed these slides actually. But if you'd like to say some word about that, the floor is all yours.
Okay. So indeed, as Michele was saying, you are welcome and invited to our webinars specifically tailored to these matters. So we will be giving one specific for the interface between plant variety rights and patents. and then another for the interface between plant variety denominations and trademarks and geographical indications. So basically, in what concerns patents, of course, it's important to understand what are the features that distinguish patents from plant variety rights. And then there is a certain interface, because plant variety rights as such cannot be protected, are not protectable or eligible for protection under a patent. However, they may fall under the scope of a patent as long as they are not individually identified in the claims of the patent. So it's interesting to explore this aspect. It's quite complex at technical level. That's why we wanted to provide a specific tailor-made webinar for this. And then on the other hand, regarding the interface with trademarks, actually what the interface relevant here is that between the plant variety denomination and the trademark. So these two, so the regulatory element, that is the denomination, and the intellectual property right, that is the trademark, they can coexist peacefully in the market as long as we can see, or we can identify the variety by its denomination. So this must be clearly affixed in design. But of course, there is also some more specific elements to explore here. So when can the trademark be an impediment to the registration of a denomination, or when can the denomination be an impediment to the registration of a trademark? So for this as well, it's a very specific area, and we wanted to provide a specific tailor-made webinar as well for this element.
Thanks a lot. So for that, the appointment is on the 8th of September. In question number 6, are the description of the granted varieties available in any database?
Yes, well, the variety description, as Angela was mentioning before, is an essential feature of the right. It's the ID card of the plant variety, and it also basically the scope of protection, the description of the protected variety. In Variety Finder, you cannot really find the complete description. However, I invite you to check the register. There is a mentioning that in the slides, and I remind you that if you want more information of how the examination was organized and more data about any candidate or granted variety, you can ask for, you have the possibility of public access. So in our website, on the basis of Regulation 1049 of 2001, anyone has the possibility to access to full file of a granted variety or a variety under examination. So do not hesitate to file a request if you do not find full information, the information that you're looking for. There is an express, a dedicated page on our website and a form. Thanks.
Thank you very much. And we're perfectly on time at 12 o'clock. There is one question. I take this one, so you don't have to do anything. How can we access to previous presentation? Nada, you will receive the follow-up email today. In the follow-up email, in the slides that I carried out, there's the training account for request for previous slides and recording. If you write us an email, you're going to be provided with any, not only the ones that have to do with CPVO, but any one topic that you might be interested in. Just write us an email at the training account. I think I still have it. Yeah, there it is. It's this one. But you'll have it in the slide as soon as you receive them, so don't worry about that. And with that, it's 12 o'clock. So I just have to do one last thing, which is thanking very, very much Angela and Ursula for today's presentation and for being so kind to answer all the questions as well. Thanks. And also thank you to all participants for the patience and for connecting and spending these couple of hours together with us. It's been a pleasure, at least for me. I hope for you as well.
Thank you for the opportunity again to raise awareness on community plant variety rights, and see you at next webinar.
Thank you. It's been a pleasure.
Bye.
Bye.
Bye.